How they sought to show that perhaps this noted forensic scientist wasn't quite as careful as he should have been.
Well, they've done it very carefully. Remember on the cross-examination of Henry Lee, the prosecution was very gentle and tried not to attack Henry Lee too much, never put his credentials into question. Well, now they're doing it through their experts. They're having their experts say, look, I am a shoe print expert. That's all I do. I write books. In fact, William Boziak says that Henry Lee's chief shoe print analyst studied under him. And he says, I know the shoe prints, and I can tell you that with regard to whether or not there could have been shoe prints, for example, on the envelope found at the scene, on a piece of paper, and on Ron Goldman's jeans, William Boziak said, those are not shoe prints. I can tell you that, even though Dr. Henry Lee said they could be shoe prints.
Well, Dan, what's ahead for the prosecution? How much more of this rebuttal is there?
Well, we expect them to rest their rebuttal case conditionally on Monday. And I say conditionally because, remember, the defense has not rested its case in chief yet. And if the defense calls some more witnesses, well, then the prosecution might have some more rebuttal.
Let's take a look at the cross-examination of William Boziak by Barry Scheck, who tried to blunt the FBI agent's attack by once again trumpeting his reputation that Henry Lee enjoys. But the witness was unimpressed.
You're aware of Dr. Lee's reputation in the forensic community?
As far as I know, he holds a fine reputation.
Right. And on scientific facts, experts can differ in their interpretations.
If that expert is adequately trained and experienced in that area and the material, the information which they're basing their opinion on is clear, they should not differ. Okay. They do in real life, but they should not.
Okay. Now, are you telling us that you think Dr. Lee is not adequately trained in the area of imprints and footwear impressions?
I have only some information regarding his training in that area. And I would believe that it's far less than mine. I've never had the opportunity to check any casework of his. I know he's checked cases of mine, and I know of no instance in which he's disagreed, but I don't have any personal knowledge firsthand of his work in shoe print analysis.
So the attack on Henry Lee, not just on his testimony, but on his credentials and on his methodology as well. Kristen Jeanette Myers joins us now in Los Angeles. Kristen, Henry Lee fired back a bit. He responded in a very unusual sort of a press conference. What do you have to say?
That's absolutely true, Terry. This testimony was heard across the country, and it made its way all the way to Dr. Lee at his Connecticut State Police Crime Lab, and he took the unusual step of calling a news conference to defend himself to the public about what Boziak had said about him hours earlier on the stand.
Only shows 2 imprints I circled. That's the only 2 imprints I testified, which Mr. Boziak agreed that's an imprint one. Both he called shoe print.
Dr. Lee, are you saying that you both may be right on this?
Sure. Scientific fact is fact. We both are right. Interpretation, I did not make any interpretation. Did I mention somebody's shoes? I did not. I said, could be a shoe print, could be something else.
So Dr. Lee's saying that he never said any of those mysterious imprints were actually shoe prints, just that they could have been. And he does stand by that. But one thing he does seem to be backing away from is this entire case, Terry. He went on to say in the news conference that he has no intention of coming back for the defense sur rebuttal case. He says he received calls from at least 5 of the lawyers, and he's saying no, he is sorry he ever got involved in this case in the first place. But of course, the defense could subpoena Dr. Lee if they do want to get him back here that bad.
Yet another very strange situation. Expert witness calling a press conference and declining to come back to testify for his side. Let's go back to Dan Abrams on one aspect of Henry Lee's statement there. He says that he only testified about 2 prints at that crime scene. Is that the way you would call it?
That's a little bit misleading, Terry, because he talked about far more than just 2 imprints. But more importantly, even if the substance of what Henry Lee is saying is generally true, and you can talk about whether or not he just means the one from June 13th, if he just means the one on the Bundy walkway, the bottom line is it was important for the prosecution to bring forward this evidence because despite what Henry Lee says, when you watch that testimony, there was an impression given about what he was saying. Barry Scheck constantly saying, could this print have been the Bruno Magli shoe that was left in blood? And Henry Lee would say no. And Barry Scheck would ask another question, well, could this be a shoe print? Henry Lee would say yes. And so it was left in these jurors' minds that we're talking about shoe prints, even though Henry Lee did make it very clear that he wasn't necessarily saying that any print, except for one print that he found later on June 25th, was actually a shoe print.
That's what experts do, testify about what they can testify to and let the lawyers draw the inferences from there. Henry Lee now getting caught up in this drawing of inferences. Let me go to Chris and Jeanette Myers on the problem that Henry Lee might now cause the defense, might now cause O.J. Simpson, because he also had something to say about the FBI crime lab. What did he say?
Well, that's true. Dr. Henry Lee says he's always had a positive experience when working with the FBI crime lab, and particularly with Special Agent Whitehurst. Now, the defense has announced its intention to call this Special Agent Whitehurst, who will criticize, we are told, the way that procedures are carried out in the FBI lab, and specifically will say that testimony is slanted in favor of the prosecution. And so a little bit of an odd twist here, having Henry Lee vouching for the good works of people in the FBI lab whenever he's encountered them. I'm not sure, given the fact that he doesn't want to come, and he's said so publicly, that the defense is really going to try and drag Henry Lee back here and put him on the stand. Instead, I think that the defense closing argument will consist of what we saw Barry Scheck doing today, which is to try and insist that Boziak and Henry Lee are really not that far apart, and that it's Marcia Clark and the prosecution that's trying to make it look like there's a big divide here. But really, Boziak and Lee are saying it's impossible to know for sure what some of those prints are, and the defense argues if you don't know for sure, the benefit of the doubt goes to the defense.
All right, Kristen Dent Myers, thanks. We're going to take a break, and when we come back, we'll begin our coverage of the day in the Simpson case with Henry Lee's rival, I suppose you could say it on the stand, William Boziak, on the witness stand, taking on Lee's findings and the defense conclusions stemming from them.
Two big values, Bravo Boss 9M, Bravo Hardbox Powerline Plus 12M. Same big amps as before, now dramatically reduced in price. The Power Vac and the Value Vac, only from Eureka.
Nothing cleans stains better than Clorox bleach. I just wish it were easier to use.
Now it is. New Clorox Cleanup Gel. It won't splash or drip. It clings to soils, penetrating them on contact, so you just wipe them away. New Clorox Cleanup Gel.
You see, this mouth is working up a hunger.
Why not build your own $1.99 meal at Long John Silver's?
Hey, fine. I'm a do-it-yourselfer.
So start building with our amazingly crunchy batter-dipped fish, tender chicken, or golden shrimp.
That'll work.
Then add two more favorites like a baked potato or buttery corn. Choose from 11 amazing tastes. Hey, you want a great $1.99 meal? Build your own and amaze your mouth at Long John Silver's.
And remember, clean your tools.
Where's that baby? I brought you a little supper. A little something. It was yummy.
Great, thanks.
A little goodie.
Good news for anyone who's ever eaten for two. The same medicine you keep handy for upset stomach and diarrhea also comforts indigestion.
I never knew that.
As Pepto-Bismol coats, it helps strengthen your stomach's protection against too much food and drink.
How's my baby?
Much better, thanks.
When you overdo it, take comfort in Pepto.
Centrum? I just feel better knowing I'm taking it.
Centrum's complete. Every time a vitamin makes news, I check my Centrum label, and Centrum's got it.
It's Centrum's commitment to ongoing research that ensures you always get the best nutritional support. A more advanced multivitamin. Centrum, always more complete than any leading brand.
The Centrum people thought of everything.
Like they say, from A to zinc.
Centrum makes a science of being more complete.
Dr. Lee, in the sections marked imprint 1, imprint 2, imprint 3, are these imprints?
Yes, sir. It's consistent with imprint.
You have made a distinction here between scientific fact and interpretation.
Yes, sir.
As far as you're concerned, are these imprints scientific fact?
Yes.
So that testimony, Henry Lee's testimony concerning imprints at the crime scene, the target of much of the prosecution's rebuttal case. Prosecutor Marcia Clark and the team on the state side having to decide where to put their energies, where to put their resources in the brief time allotted them in rebuttal, brief because of the exhaustion level of the jury, and they decided to go after Henry Lee. On the witness stand today for the state, FBI Special Agent William Boziak, here under Marcia Clark's direct examination, tells the jury that Henry Lee's interpretation of those prints could be misleading.
Now, you indicated to us that you did hear some portions of Dr. Lee's testimony, correct?
I heard the majority of it, yes.
And in that, he was pointing out various marks that he thought could be imprints. Do you recall that portion of his testimony?
Yes, ma'am, I do.
Sir, do you have an opinion as to whether it is appropriate to point out marks or things that could be imprints but cannot definitely be characterized one way or another?
I was first a little confused by the term imprint that was used so loosely to describe so many different things. I have no problem with the term imprint because in the area of impression marks, it's a well-known fact that around the world, different terminology is used to describe shoe impressions. For instance, in England and much of Europe, a two-dimensional impression would be a mark. A three-dimensional would be a depressed mark. I like to use the term impression to cover everything because I think it's less confusing, or shoe print. I think the term imprint is probably more of a general term, and so I had a hard time understanding when Dr. Lee pointed to many different things and referred to them all as imprints, exactly what in his mind he was inferring, although he seemed to, when questioned about it, admit that he couldn't say it was a shoe print. So I was a little confused by some of his testimony.
If, in fact, Mr. Boziak, I look at a photograph, I'm a layperson, correct?
Yes.
I look at a photograph, and I can't really see imprints. You think you may see something. Under those circumstances, do you think it's appropriate to render an opinion concerning the possibility of the existence of imprints that may have forensic significance?
You might want to make a statement about it, but it should be a qualified statement so that it's understood that there are limitations. Perhaps you can't exclude it as having been made by an object, whether it be a shoe or fabric, but not to infer that it is if there is less than optimal detail.
In other words, if we can't all see it, is it appropriate to say, I as an expert can see maybe there might be something? In other words, if we can't all see it, is it appropriate to characterize it?
Oh, well. Now, if being an expert in an area doesn't give you any better than 20/20 vision, if as an expert you see something, everyone should be able to see that clearly. You should never point to something and say, I can see this, knowing that no one else can see it.
Move to strike.
A flat-out commentary, criticism of the testimony of one expert by another expert, William Boziak, who is in shoes. He spends a lot of time in looking at shoes, shoe prints, and claiming here on the witness stand that the testimony concerning imprints at the crime scene by Dr. Henry Lee just isn't right. When we come back, we'll hear more of William Boziak's testimony as he describes specific markings at the crime scene that Henry Lee contended might have been imprints. Boziak disagrees.
And did you discuss with him?
My asthma struck as my daughter started crying. It wasn't the time to try some unknown brand. I trust Primatene.
It starts to open clogged breathing passages in as fast as 15 seconds.
She depends on me. I depend on Primatene Mist.
Fastest type asthma relief without a prescription.
My doctor said I didn't need surgery for my hemorrhoids. They weren't serious. And to use Preparation H. Preparation H is so effective, it helps relieve my worst symptoms. Yet it's so gentle, it soothes and protects. More people trust doctor-recommended Preparation H.
Oh, no. This leaky pen could have turned your expensive shirt into dust rags. But DD7 saved the day. Just a little dab of DD7, the spot and stain remover, and your shirt is as good as new. Even on the most delicate fabrics, the super concentrated power gently lifts out even the worst stains. Red dye turns your laundry pink, or ink from a pen. A little DD7, now you see it, now you don't. Join the millions who save money on clothes and dry cleaning, all because of DD7, the spot and stain remover. Pick up yours at these fine retailers today.
Sprint Sense International gives you great rates to countries all over the world. What more could you want?
How about some cash?
Cash would be good. Yes, some cash back.
Presenting Sprint Sense International with something new, cash back. Call now for these simply great rates on calls to countries all around the world. Plus, get rewarded with 10% cash back for every dollar you spend.
For me, that would be at least $100 a year.
Cash back on all my calls to Ireland?
There's no limit to the amount of cash back you can earn. Month after month, you'll see your cash add up, so it pays to stay with Sprint. Call now and we'll even switch you for free.
What about domestic calls?
You'll get cash back on domestic calls, too. And with Sprint Sense International, you'll get a great 10 cents a minute rate on every state-to-state call. So call now.
Cash back would be great.
Good idea.
Cash back. It's one phrase that's understood around the world. Get simply great rates now and 10% cash back every year. Call now, 1-800-227-9878.
Much of Henry Lee's testimony for the defense in this case was based on his very close, very careful examination of photographs of the crime scene. He did, in fact, visit the crime scene at Nicole Brown Simpson's condominium, but much of his testimony was based on his examination of these photographs. And today, for the prosecution, FBI agent William Boziak criticized that procedure a bit, especially in light of the fact that Henry Lee was using second-generation photographs, copies of the originals. Here's his testimony under Marcia Clark's questioning on that point.
Now, the photographs that you examined, sir, were they original photographs developed from the negative?
They were first-generation photographs from the negative, yes.
Did you hear Dr. Lee's testimony that the photographs he examined were second generation, that is, a photograph of a photograph?
Yes.
Sustain.
In some instances, did you hear Dr. Lee's testimony with respect to some of the Bundy walkway photographs, that what he examined were photographs of photographs?
Yes, ma'am, I did.
What is your opinion of the practice of forming an opinion based on the appearance of a photograph of a photograph?
Oh. In some instances, you could reach a conclusion with a photograph of a photograph, particularly eliminations. If there was a design, even though the photograph were poor, that the design was definitely a different design, you could still see that. You could reach an opinion. You might also be able to reach certain qualified opinions, but using a second-generation photograph is generally not what you strive to do in your examinations, because there always is the possibility that the original full-framed picture from the original negatives contains much more information. It might even contain other areas that you don't see on a copy of that first photograph. So as a general rule, it's dangerous to work with that kind of material. It's limited.
Now, you are aware that the people provided the defense with original...
Your Honor. Ask for sidebar. No, sit down. Sustained. Argumentative, counsel.
Have you spoken with Mr. Scheck at some length, sir, prior to your testimony today?
Yes, I have.
And have you gone over photographs with him, sir?
Yes, I have.
And have you seen original, that is, first-generation photographs in the possession of Mr. Scheck?
Most of the photographs that we went over were photographs that I generated, or the LAPD had generated from the original negatives.
And did you discuss with him the providing to Mr. Lee of second-generation photographs in lieu of original photographs?
I don't recall any specific discussion about that. There may have been a reference to it, but I don't recall it as a discussion.
Let me put it to you this way, sir. If the prosecution had sent to you photographs of photographs, second-generation photographs, and asked for you to render an opinion characterizing or forming a conclusion based on those photographs, would you do so?
That happens quite frequently because a lot of departments don't want to give up their original photographs or negatives, and I pick up the phone and call them and explain to them for various reasons why I have to have the best evidence. And I usually won't do the examination, even a qualified one, if I don't have that.
Well, it's a battle of the experts and an important one in the trial of O.J. Simpson. And to help us understand it, tonight we're fortunate to be joined once again by Bob Gottlieb, who is our guest commentator tonight. Criminal defense attorney here in New York City, has tried about 50 murder cases, both as a defense attorney and as a prosecutor, federal and local prosecutor. It's good to see you again, Bob.
Thanks a lot.
This battle of the experts, what does it tell you about the prosecution's case here, that so much of their time is being spent going after Henry Lee?
Well, I think they felt that beginning with Dr. Bodden, the pathologist, and Henry Lee, their case was falling apart at the seams. I don't think there's any question. People have been following this case on court TV, reading about it. You had a general sense over the last few weeks that the prosecution's case was evaporating. People were no longer talking about conviction or hung jury. They were talking about outright acquittal because now there was this second set of footprints. There was another murderer, and therefore the entire prosecution theory was out the window. And the thing with Furman, everything was just going down the tubes. Now they had solid proof that the key expert put up by the defense was just wrong. And it's really the way you would want to end a case if you're a prosecutor.
Wrong on some very tactile things you can get your hands on. That's not an imprint on the tile, and we'll hear this. That's the way the tile's made. That's got to hurt if you're the defense lawyer.
Well, it does have to hurt. You know, it's one of those situations as a defense attorney, especially when the prosecution's putting on a witness on rebuttal, somebody who you're really not sure, what is he going to say on rebuttal? As a defense attorney, you sort of are waiting for the guy to get on the stand. You're saying to yourself, I wonder what this guy is going to say. Then when the guy says they were not imprints of shoes, but they were in the cement and the tile, and he has pictures, it's the sort of reaction as a defense attorney you're saying, oh, geez, did we have to end on this note? It's not one of those great days for a defense attorney.
Because those imprints might still be there, and we'll get to them. This testimony that we've heard from Boziak so far, he's commenting directly under Marcia Clark's questioning. This is why Henry Lee is wrong. This is why he did it wrong. How common a manner of expert testimony is that? Just to pit one expert against the other and have them go after each other?
Well, you'll always pit an expert against another. That's appropriate. But what the difference is here, and Barry Scheck objected, you heard a moment ago, and the judge really slapped him down and said, sit down. But Barry Scheck was right, because what was happening now is he was not commenting on the evidence, and this, based on my review of the evidence, is why Henry Lee is wrong. He was simply saying, Henry Lee is wrong. He doesn't know what he's talking about. If I were Henry Lee, I wouldn't have accepted a second-generation photograph. That's so speculative. It's really over the line, and a judge properly would have sustained an objection and said, you can explain why you disagree with Henry Lee, but don't just give a jury your conclusion about his credibility, because the issue of credibility as to who's telling the truth is finally up to the jury and only the jury. This witness's opinion about Henry Lee's credibility is irrelevant.
That objection wasn't sustained, though. It was overruled.
So what's new?
All right, we're going to take a break. When we come back, we'll continue our coverage of the O.J. Simpson trial as William Boziak turns his attention to the specific evidence that Henry Lee was pointing at, imprints, Henry Lee said, which Boziak claims are just markings in the concrete that you will still see on South Bundy.
Plug into a new world with America Online. Get unlimited email, Court TV's Law Center, access to the Internet, and more. Call for free software and a free trial. Call 1-800-641-8866.
Whoa, this game's awesome. All right, here he comes again. Use your firepower. Yeah, shoot him, shoot him, shoot him. Whoa, watch out, stop. Yeah, that's it. Get him. Fire, fire. Going down. Turbo blast him. Oh, right. He's almost out of power. Keep firing. In the face, in the face. Yeah, you're on the high scoreboard. Keep going. Shoot him again. Got it. Oh, right, Dad. Oh. Hey, you got another quarter?
Any air freshener can freshen a small room. But what about a large room? Introducing Glade plug-ins for large rooms. The first air freshener specially designed for your largest rooms. Because it gently warms not one, but two cartridges for large room freshness. Plug into large room freshness from Glade. S.C. Johnson Wax.
Do the extra thing. Take the extra... This is a rare glimpse of something few people will ever see. A special training session for ERA real estate associates who are learning to be more successful, getting better results for their clients, and living up to the words ERA first in service. That's me, Dustin Secor. I'm an ERA national trainer. When these graduates leave here, they're producing over 3.5 times the national real estate average. That's because I teach them how to sell a house 38 days faster, show it to a 40% bigger market, even how they can guarantee its sale for their clients.
4 listings sold. 4 new...
If you want to help people get results with the best products and services in the industry, then call now. Great training and great results. That's why the best place to work is with the local ERA broker.
If you think you can qualify to be one of ERA's best, call 1-800-406-2992. ERA, first in service.
What have you learned from the O.J. Simpson trial so far? That real justice is messy, unpredictable, riveting, important. That's the truth behind our entire legal system. That's why Court TV takes you far beyond the camera in the courtroom. Every weeknight after Primetime Justice, watch the whole spectrum of America's legal system, from investigation to confrontation to the aftermath of the verdict. Court TV weeknights after Primetime Justice. Real drama, real people, different television.
For the latest programming information seen on Court TV, call 1-800-COURT-56.
Incidentally, Dr. Lee, with respect to the parallel line imprint pattern that you identified for us on this June 12th, June 13th walkway photograph, in theory, is it possible that that imprint pattern could arise from an imperfection in the tile?
It could be, because I only look at the picture. I, myself, did not have an opportunity to go there, identify the tile. It could be anything.
Well, that line of testimony got lost in Henry Lee's explosive findings or suggestion that in the walkway or at the walkway at Nicole Brown Simpson's condominium there might have been another shoe print. At least that was the inference drawn by defense lawyers. But there, as you see, Henry Lee very careful to say he didn't actually go and look at the walkway after seeing this photograph, and he was just judging from the photograph. Well, William Boziak did go back to that walkway after Henry Lee's testimony on September 1st of this year, 1995, and he took a picture. And today, under the questioning of Marshall Clark, he showed the jurors what he found, and what he said refutes any notion that there is another footprint at that spot.
All right, so directing your attention specifically now to the photograph that I'm going to start labeling them, Your Honor, for the record. The upper photograph labeled color photograph with the shoe print A, and the black and white below it B. Directing your attention to photograph B, sir. That appears to be a black and white photograph.
It is a black and white photograph.
Can you tell us when that photograph was taken?
That particular photograph I didn't take. To the best of my knowledge, I believe it was September 1st, 1995.
1995?
Yes.
And did you direct that it be taken black and white like this?
I gave general directions to how to take the photographs of the tile using an oblique light source and the camera on a tripod and a scale and everything in the photograph.
Can you explain to us what you mean exactly by oblique light source?
Yes, oblique light is when the light skims the surface, as opposed to light just coming down from overhead as it would if you were to walk outside or in a room such as this where the lighting is coming from overhead. And when the light comes from overhead, it is very even and does not give you a lot of contrast regarding surface detail. If you were to turn these lights off and bring a bright light in here and skim the surface of different objects, you would see the texture, the carpeting texture, shoe prints that might be depressed, other tool marks or marks on objects. You would see them much better because the low light would be creating shadows in the low areas of these uneven things and would highlight the upper areas, and it would give you better contrast. So you would be able to, by skimming the light along the surface, see those defects much better in the walkway.
Okay, so does the oblique lighting create new features that were not there?
It doesn't create features. It enables you to see them much better than you might be able to see with photographs taken with other lighting sources.
Now, what was the purpose in this particular case of asking that these black and white photographs be taken with oblique lighting in September of 1995?
After Dr. Lee's testimony regarding this particular imprint, which is the original photograph of which is depicted in photograph A on this board, in order to obtain a picture that shows more clearly that mark, I directed them to take this different type of photograph.
Now, the parallel lines that appear in People's 45I and on the defendant's exhibit 1337 that you've circled with the laser light, can you tell us whether you were able to locate that particular tile, that location on the Bundy walkway after Dr. Lee's testimony?
Yes, that was the edge, this particular edge here, and this photograph A on this board is the same as the area I just circled. This edge is the border between the second and third row of tiles, and it is in the area of the impression, this particular impression, which we labeled E on the original, the Bruno Mali design and the original Bundy walkway board.
Okay. And for the record, Your Honor, I've placed labels A and B. Now, directing your attention to photograph B, the photograph taken September of 1995. Can you tell us, sir, whether that is the exact location depicted in photograph A, which was taken on June 13th, 1994?
Yes, it is. The grout line, which is running up and down this, corresponds with this grout line, and this tile to the right of the photograph, or on the right side of the photograph, B as you face it, corresponds with the heel portion, or the part of the tile on the heel area, which is actually the second row of tiles on the photograph A.
Now, the parallel lines that were testified to by Dr. Lee, do you see them in the photograph taken in September of 1995, labeled on this exhibit as B?
Yes, the same lines are right in this area, and they are the same lines that you can still see it in photograph A as you can when I pointed it to the laser, but you can see it much more clearly in photograph B.
Then with respect to the parallel lines that were pointed out during Dr. Lee's testimony in photograph A and what's shown on the screen in People's 45I, in your opinion, sir, is that an imprint?
No, it's not an imprint, nor is it a shoe print.
What is it?
It's a result of the finishing of the concrete tiles. Much of the discussion, including my own, of the Bundy walkway has referred to the individual squares as tiles. In fact, they are not actually tiles in the sense that they could be picked up maybe an inch or a quarter inch thick and it would be laid down and filled in with concrete. On the other hand, they are actually poured concrete and they are grouted to make it look like individual tiles. So this was actually a walkway that was poured with concrete, and certain tools were used to finish that concrete, just as it would have been if it had been a plain concrete walkway.
So when you were there, did you notice many marks and defects inherent in the concrete itself?
Yes, I did.
I'm going to place the label C on the photograph that appears to have what looks like a shoe print in the cement, and ask you if you had seen that particular feature, sir.
Yes. In this particular photograph, which is on the second tier, the seventh row of tiles, there was actually almost an entire well-defined shoe print of a left shoe that was made by stepping in the concrete tile before it was dried. And it was there since the day this tile was poured, and I imagine it will always be there.
Is it a Bruno Mali shoe, sir?
No, it's not.
And so a very innocent explanation, according to FBI agent William Boziak, for what the defense has been suggesting is a very sinister potential piece of evidence, another imprint, another shoe print at the crime scene. Bob Gottlieb, this is the kind of thing that jurors can appreciate, isn't it?
Well, yeah, this is good stuff. This is clean. It's clear. The guy isn't on the stand for 5 days talking about a lot of letters that nobody has, or everyone has no idea what the guy's talking about. It's very narrow. It's focused. This is what the trial should be from beginning to end.
You know, it's also the kind of evidence that they could get their hands on. Let's say that in deliberations they want to go back and take a look. Would they be able to?
There are two things. No, in deliberations, could they go back? Yes, a judge, because they've already gone there, a judge could arrange that. But in a case like this, where the prosecution, just in the beginning of September, realized, wait a second, we got them. Because, look, it's actually in the concrete. What they could have done is, rather than ask the judge to bring them back to the scene, they could have arranged to have some contractor come in, cut out the square, a nice big square, and come into the courtroom through this witness, not only with a black and white photograph, but with the cement itself, with the imprint itself. Let the jury see it. Let the jury feel it. Let the jury pass it around. Jurors love that. And you know what? That's the best evidence.
And you had a case where that worked for you.
That's right. We actually had a case when I was a prosecutor where the issue was how much force did the person use when he implanted an ice pick in the person's skull. And the only way to really get a feel for that was we arranged to cut around the ice pick, the person's skull, and we actually brought into the courtroom about 2 inches of the person's skull with the ice pick still embedded in it. Nobody likes to hear about it, but for the jury, that was as graphic a way to show the force that the defendant had to use to implant that ice pick.
On the other side, then, given the tactile, the real power of this evidence, what can a defense lawyer do if, as seems here, they got you?
There's not a heck of a lot on this issue. The defense still has many issues in this case. They have the issues of the contamination. They have the issues of Furman, whatever the jury actually will remember about Furman rather than what the public knows about Furman. So you really have to, when they got you, you have to quickly go through your cross-examination, not make it appear as if the case is over and they've beaten you. You don't flinch, you don't move a muscle, you don't let the jury know that today is not the best day of the trial, and you move on and you now try in your rebuttal, in your cross-examination, to only now focus on your strong points. You don't want to end on a low point, even as a defendant.
And what do you do if you're the expert witness? Do you go out and hold a press conference and say, this is not a good thing, my integrity is being challenged?
You know what's interesting here? What Dr. Lee is saying, and I think he's right, is he never said that, in fact, is a second shoe print. He never said that. But clearly the impression that was given to the jury during the questioning, clearly the impression since he got off the stand was we have two shoe prints. There are two different imprints. We didn't hear from Dr. Lee correcting the statements by the attorneys and the media. We didn't hear it until today when it was clearly clarified by the prosecution witness. Dr. Lee, more than anything else, is a professional. He has a reputation. So today, when it looked as if he was caught and with his pants down, he wanted to clear the record so that people do not think he was trying to fudge the truth.
And now Henry Lee has said he wants a little distance from the O.J. Simpson trial. He doesn't want to come back for a rebuttal, and he says he regrets getting involved. One almost can't blame him. When we come back, we're going to continue our coverage of William Boziak's testimony as he continues to take on Henry Lee.
Are you getting all the relief you need for arthritis pain? Discover the first in a unique class of pain reliever doctors have trusted for years. Zostrix. So effective that even though prescriptions have never been required, doctors prescribe Zostrix and triple-strength Zostrix HP more than all other topical arthritis pain relievers combined. Zostrix is also proven to work hand-in-hand with oral medications for added relief, greater mobility. Zostrix, physician strength relief, is in your hands.
Popping with flavor, more flavor than ever, and less fat, too. It's the right thing to do. Popping with flavor. Pringles right crisp flavors, they're new. And the taste indulging right thing to do. Tangy, sour cream and onion, now more flavor on the tin. Less fat and less grease across the lid. Popping with flavor. Pringles right crisp flavor. Once you pop, you can't stop.
Out the trash. The new A Current Affair. Check your local listings for time and station.
Look around. Can you guess who showered with soap this morning? And who showered with Zest? You see, soap leaves a drying film that's not easy to see, but you sure can feel. But Zest rinses clean away, so all you feel is clean. So why feel this dry when you can feel this smooth? With cleaner, smoother feeling skin, compliments of Zest. And smooth.
William Boziak took on Henry Lee on a variety of issues today. The FBI agent testified that Henry Lee was mistaken when he suggested that an imprint at Nicole Brown Simpson's condominium could have been left by a killer on June 12, 1994, because Boziak said that imprint is still there. And he also explained to the jury why he thinks Henry Lee might have gotten it wrong. That's because Henry Lee didn't visit the crime scene sufficiently.
Those imprints identified by Dr. Lee in 1337 on the board behind you, the three lower photographs. Okay, with the exception of the one that you have identified, the photograph to the far left, in which the imprints that Dr. Lee testified to, you have determined were trowel marks. Other than that, the other two imprints that Dr. Lee testified to in the photographs dated 6/25/94, do either of those have the appearance of having been made as a result of stepping in a pool of blood?
I'd like to answer those separately. First, the center photograph, which is the parallel marks in the corner that we've just been talking about, as well as the other discolorations, which, looking to that area on photograph H on the magnetized board, those areas just simply didn't exist. There was no impression there on June 13th, 1994, and therefore, whatever these marks are here now on June 25th are not related to the crime. With regard to these parallel impressions, the very thin parallel lines, they may be a shoe impression, but there is no evidence of them in photographs J and K on the magnetized board, which depict that second, in the 10th row of tiles, the second tile, adjacent to K and H, and also in between H and I. They do not appear there in any of the general crime scene photographs, and I would believe that based on the fact they don't appear there, and they were not photographed at that time, I see no reason why they would have been there on June 13th.
Move to strike my foundation.
Well,
Then with respect to People's 598, sir, in photographs H, I, and F, do these constitute clear photographic proof that the imprint shown in the June 25th photograph of Dr. Lee, labeled F, was not there on June the 13th, 1994?
This is absolute proof that it did not exist on June 13th, 1994.
And would that tend to indicate then, sir, that it was deposited at some time after the murders occurred and after the murderer left the scene?
Whatever occurrence or occurrences caused these discolorations in this area and these lines would have had to have occurred after June 13th, 1994. And these are not trowel marks. These are other discolorations.
And, sir, based on your analysis of all of the evidence, including Dr. Lee's photographs, is there any evidence that more than one set of bloody shoe prints were left at the scene at the time of the murders?
No, there is not.
And all those shoe prints you identified at Bundy, were they made by size 12 Bruno Magli shoes?
All of the bloody shoe impressions, which I previously testified to, were made by size 12 Bruno Magli designs, and there is no other shoe impressions that I examined or saw in any of the evidence that I've seen in this case that were there on June 13th, 1994.
And since your testimony, you've heard Dr. Lee's testimony in large part, correct?
Yes, I have.
And you have seen his exhibits?
Yes, I have.
Has anything you've seen or heard since your testimony in this case when you previously appeared that causes you to waver at all in your opinion that there was one set of shoe prints on June the 13th, 1994 at Bundy, all of which were size 12 Bruno Magli prints?
Nothing has changed my opinion, no.
And has anything you've seen or heard caused you to change your opinion that the defendant is included as a candidate for wearing those size 12 Bruno Magli shoes?
No.
Thank you, sir. I have nothing further.
So that's the way Prosecutor Marsha Clark finished up her direct examination of this key prosecution rebuttal witness, William Boziak, not only by taking on Henry Lee, but the defendant as well, reminding the jurors that the shoe prints that are undoubtedly at the crime scene are size 12 Bruno Magli shoes. Bob Gottlieb, this is the kind of examination that the prosecutor likes to end up on. You talked about ending up on a high point. She turned it right back against O.J. Simpson.
Yeah, well, that's really what the trial is all about. It wasn't about Furman, even though the defense properly tried to divert the issues to somebody else. That's what defense attorneys ideally want to do. But especially on your rebuttal case as a prosecutor, you want to get it right back to what the case is all about, and slowly they're chipping away to all those things that were sort of dangling out there, which might add up to reasonable doubt. They're beginning to dissipate. They're beginning to evaporate now.
You know, when you've had a witness disaster, like the Mark Furman disaster for the prosecution, I'm not sure there's ever been one like that, but when you have a witness go south on you, how much does it affect expert testimony in the case, your expert testimony?
I don't think it has any impact on the expert. What I do think it potentially can have an impact on is your concentration, the way you handle the rest of your case. A trial is a marathon, and any good trial lawyer knows that you have good days and you have bad days. The prosecutors had many bad days here, but this case was so long they had more good days. And it took a lot, and they deserve somewhat to have some credit now that they kept focused. They knew that on rebuttal they potentially had this information, and they got the trial back on track. So they deserve credit for that.
Now, on the imprint testimony on Ron Goldman's jeans, which we heard rebuttal testimony on yesterday, was again the prosecution trying to show that it was his own clothes which caused what Dr. Lee said might have been, or what the defense suggested might have been, other shoe prints. Is the prosecution able, through this testimony, to bring the focus back to the victims at all?
I don't think that's what this is all about. I really do think it's about taking care of the loose ends, all of those doubts that people, the general public, was talking about, as well as I'm sure what the jury will be talking about when they begin to deliberate. They are beginning, and they want very much just to show that everything that you might have said created a doubt in your mind no longer exists. Whether or not it's going to work remains to be seen, because there's a lot more that's out there that might justify a juror saying that I have reasonable doubt. But I think the reason for this type of testimony was to get back on the evidence against the defendant.
And the circumstances that these jurors are in to receive that evidence, unique, absolutely. When we come back, we'll talk a little bit about what these jurors have been through, where they are at this point in the case, perhaps, with our reporter in Los Angeles, Dan Abrams, and we'll be joined by a jury consultant here. Stay with us.
Back in 1964, this car cost me less than $2,400. Now, that same year, I bought my first Globe life insurance policy. It only cost $1 to start, and I've had that same policy now for over 30 years. Today, it would cost 10 times as much to buy a new model, but you can still start a Globe life insurance policy for $1. Now, that was a good value for me over 30 years ago, and an even better value for you today. Call right now to receive complete information about Globe's $10,000 long life policy. You'll learn how $1 is all it costs to start a long life policy that can provide your family financial support when they need it the most. Globe makes buying life insurance simple and easy. Maybe that's why millions of people have Globe policies. Call Globe today.
To receive complete information and applications by return mail, call Globe at 1-800-253-6100. Call Globe today.
You've probably seen commercials for siding from Sears. How dramatically it can change the appearance of a home and keep it looking new without ever painting again. Then you've also seen how expertly Sears can permanently cover eaves and overhangs too. How siding from Sears ruggedly stands up to wear and tear and weather at its worst. You've seen where Sears quality starts with thick Dow styrofoam insulation under the siding. Now you should see something else. This free, informative siding video. Call toll-free today and ask for your copy. There's absolutely no obligation. This helpful video shows you in greater detail why siding from Sears is the right choice when you want to forget the work and expense of scraping and painting your home once and for all. You also hear firsthand from satisfied customers all over the country why Sears is the best choice for premium vinyl siding. Call for your free siding video now and get the whole story from Sears, the most trusted name around the house.
Still ahead on Primetime Justice, cross-examination of shoe imprint expert William Boziak. Was it successful for the defense? And later we'll turn our focus to the trial from Florida, where Peter Lopez is charged with murdering a young man at a benefit concert. Tonight, a friend of Lopez's gives his version of what happened on the fatal night.
What was your observation of his demeanor, his behavior?
I couldn't judge how his behavior was. Like I said, he just mentioned that he wanted to get a gun.
Straight ahead on Primetime Justice.
For the latest verdicts and information from the trials covered on Court TV, you're invited to call the Court TV verdict line at 1-800-COURT-56.
You are the most common household problem today.
Well, excuse me, but if I'm a household problem, it's because you didn't get me the purebred mitt. That wonderful mitt that would rid my coat of irritating, dead, loose hair. Every animal should have one. It's so soothing, we don't even know we're being groomed. But you'll know by the piles of loose hair attached to purebred. Just look at the mess it gets out. Listen, all you pets out there, if your owner keeps forgetting you need a purebred pet mitt, have I got a deal for you.
Introducing the Purebred Shampooch, especially designed for applying those nasty things like shampoos and flea killers. Watch. Pour some shampoo in here and then brush. Those extra long, flexible fingers get right down to the skin, releasing the shampoo with each gentle stroke. The secret is the hollow fingers that release the liquid right where it's needed most, deep down in their coat. No more humiliating bubble baths. With the Shampooch, bath time is a relaxing, fun time, and you can forget those awful flea treatments, too. That nasty stuff gets everywhere. But with the gentle Shampooch, it's applied cleanly, effectively, not up their nose or in their mouth. Yes, the Purebred Shampooch is a pet's best friend, and a bargain at $8.95. But listen to this. If you order the Purebred Mitt today for $14.95, you'll receive the Shampooch at no extra charge. That's right, you'll get both for just $14.95. So do your pet a favor. Grab the phone and get ready to dial.
You do know how to dial, don't you?
Use your credit card and call now toll-free 1-800-767-1100 or send check or money order for $14.95 plus $4.95 shipping to Purebred, Box 1111, Deerfield Beach, Florida. You get the Purebred Mitt plus the bonus Purebred brush at no extra charge. So call 1-800-767-1100 now.
Continuing Monday on Court TV. It was a night of celebration, festivity, and goodwill. But Peter Lopez changed it all in an instant.
He gets out, he aims over the hood. People start running.
Why did a fundraiser for struggling musicians erupt into chaos and death?
He met with his death with a gunshot wound.
Did Lopez have a plan to kill? Or was it a tragic accident that could have been avoided?
Never intended to shoot anybody.
Florida versus Lopez, continuing Monday.
If you're interested in purchasing any footage that you've seen on Court TV, call the Video Library Service at 1-800-888-4580.
I don't want to be overly dramatic about this with you, but I want you to know that it pains me deeply to know that you're there and that we're not accomplishing things, and it seems to you that we're not moving forward. And I can't think of any other way to express it other than to tell you that I'm deeply sorry.
That was Judge Lance Ito sounding a very familiar refrain in the trial of O.J. Simpson, apologizing to the jury, basing himself almost before the jury for the long delays, the long periods where this sequestered jury, day 249, I believe, of sequestration now, not heard testimony. Today, once again, Judge Lance Ito had something to say to the jury and tried to buck them up a little bit as well.
I wanted to compliment you on your continuing level of attention. I can tell by the expression on your faces every day that you're all tired, almost as tired as I am. But I know you're hanging in there because I've noticed that when certain items have come up that obviously you're very attentive as to which item of evidence is which, and I've seen you react to things that indicate to me that you're clearly as much on top of this as some of the lawyers, and maybe more so than me, as far as the numbering of the exhibits, and I know you're paying attention. I know it's tough, but hang in there. We're almost there.
Well, it is a fairly impressive feat of civic service for these jurors to have been in this courtroom over 30 weeks and followed the evidence in this case as closely as it seems they have. Let's go out to our reporter who's in the courtroom with them. Dan Abrams joins us once again from Los Angeles. And Dan, let me begin with what happened in court today, one of those instances that catch jurors' attention that may or may not have any impact on the trial, but is just also interesting. What happened?
Well, Terry, right before the lunch break, all of the media and the public is walking out of the courtroom. The jury sits there and waits for everyone to leave. The defense attorneys stay at their table, the prosecution basically staying at their table, and everyone sort of watches us walk out. Well, most of the time, O.J. Simpson is just facing ahead. This time, as the jury is facing O.J. Simpson was completely turned around, watching, in particular, a Cub Scout or Boy Scout as he was walking out of the courtroom. And it was interesting because O.J. Simpson was following this boy with his eyes. And then right before the boy actually walked out of the courtroom, O.J. Simpson gave him a thumbs up and winked at him and said either something like, "Go, boss," or "Yo, boss," something to that extent. But the jurors are watching O.J. Simpson. And so who knows if O.J. Simpson was doing it for the jury or just because he was admiring a young boy. But it is one of those little instances inside that courtroom that the jurors must pick up on.
And it may endear the defendant to them. It may seem odd. It's one of those extra testimonial aspects of life inside the courtroom. And then at this point in the trial, there's a lot of talk about the jurors being very impatient and disgruntled with what's going on. Do you get any sense of that during the course of testimony?
Well, today we did in particular, Terry. You heard Judge Ito a few moments ago complimenting the jury on following what was going on. The reason he said that is because there was one point when Marcia Clark and Barry Scheck were confused about exactly which letter was associated with a particular exhibit. Was it J or K? And then you saw a couple of the jurors help Marcia Clark out in determining exactly which letter this exhibit was. Well, as they were sitting there debating it for about 15 or 20 seconds and the jurors were chiming in, one of the jurors, juror number 5, an African-American woman about 38 years old, finally said, "Let's go." And so finally a juror getting to tell these attorneys exactly how she feels about the pace of this trial.
A little jury power inside Judge Lance Ito's courtroom. There's been a lot of that kind of power exercised, and who knows, it may change the dynamics of juries in courtrooms across the country. We're joined now by a jury expert to try to understand what's going on in the Simpson case. Robert Hirschhorn is with us. He is a trial consultant based in Texas whose job is to review and analyze the pretrial information, help lawyers pick jurors. Some of the noted cases he's been on include the William Kennedy Smith trial, the Branch Davidians trial, the trial in Waco, Texas, in San Antonio, I should say. It's good to have you with us, Robert.
Thank you, Terry. I appreciate it.
What do you think at this point in the trial of a sequestered jury, how much they can grasp of what may in fact be important testimony, where they are right now?
Terry, I think there's no doubt the juror summed it up. Let's go.
let's get the case to the jury. I mean, out of the mouths of babes come the truth, and there it was. It was a perfect pearl to say to the lawyers, move up, get going, and let's get out of here. Because the jury, I think, Terry, they heard 6 months from the prosecution, they've heard 2 months from the defense. I think they have all the information they need. One of the questions that I wanted to ask Dan, I know he's in there with the jury, whether or not, Dan, you've noticed any change in the pattern of note-taking from any of the jurors. And the other thing I wanted to know is whether or not you noticed that during any of the testimony, when the prosecution is talking, if any of the jurors lean forward, or when the defense is talking, any of them pull back like this. Have you noticed anything like that?
Well, let me start first with the note-taking issue. There is a wide disparity in note-taking depending on what type of testimony we're hearing. The jurors seem like normal people in that when their conclusion is drawn, they seem to take a lot of notes. But I'll tell you, a lot of the time on redirect examination, recross examination, when they're getting into minute points, no one is taking any notes. I mean, and particularly when you're talking about some of the DNA evidence, not about the actual numbers or the results. When they get a chart up there, it seems like the jurors are taking notes, not writing down everything that's on the chart, but writing down some of the figures. But when they're talking about how they came to those conclusions, none of the jurors are taking notes. They don't take notes during the credentials at all with regard to a lot of this testimony. I forgot what the second part of your question was.
The body language, Dan.
Oh, there's one juror in particular, an alternate juror. And I'm not a jury expert, but I can tell you that this gentleman, an elderly African-American gentleman, only takes notes, it appears to me, when the defense is making points. Now, it could be that we've seen what he says in some of the sidebars. He seems like someone who's concerned about racism, who said about the sheriff's department, these type of people have been pushing me around all my life. But I can tell you that even when the most minute points are made by the defense on cross-examination, he seems to write it down. But when the prosecution is making a broad point, what might seem to be a very important point, he doesn't write it down. For example, Richard Rubin, the glove expert, was on the stand, talking about some very important testimony for the prosecution. He took almost no notes. But when the defense asked him about whether or not he'd asked the prosecution for their business cards and talked about the victory party in a letter he'd written to the prosecution, he'd said, I'm looking forward to coming to the victory party, this man starts scribbling down notes. Now, who knows exactly what he's writing, but that, hopefully, is the answer to the question.
Who knows, indeed. Let me bring Bob Gottlieb into this. Who knows? Robert Hirschhorn's job, his profession here, is to take a look at juries, help lawyers craft juries or select juries. Can you obsess about them too much when you're doing the trial work? Because it is reading tea leaves.
Well, I don't think you can obsess too much. I think, in fact, jury selection is the most critical point, because no matter how great your case is, if you really blow it, if you totally misread a juror, you're out. So it is a critical stage of the entire process. Now, whether or not an expert, and Robert has the greatest reputation in this area, is the key to it really remains to be seen. But whatever edge I, as a defense attorney, or even if I were a prosecutor, any edge I could get, I would bring him in a moment, and then I would listen to him. But ultimately, the decision as to what to do with a juror really has got to be up to the defense attorney in consultation with his client, and perhaps even the jury consultant.
Well, I just want to open the floor now, since we have Dan Abrams, who's been inside that courtroom all the time. Robert, if you have something else for Dan, fire away.
Yeah, Dan, one of the questions I wanted to ask you is that in terms of the jurors, have you noticed any of them spending time looking at O.J. Simpson? And more importantly, when the lawyers go to the bench conference, and all of us that have been following this trial know, boy, a lot of time has been spent up at the bench, what are the jurors looking at? Who are they talking to? Are they looking at O.J.? What are they doing? And by the way, Dan, one last point. I think you'd make a great trial consultant. You spent a lot of time in that courtroom watching that jury.
Yeah, maybe too much time. The jurors during the sidebars do chat with one another sometimes. But it's interesting. It depends on what type of testimony it seems that we're having. For example, when we were having some of the photographs shown, some of the gory photographs, none of the jurors were speaking to one another. They were really sitting there in silence. But when we've had some of the lighter witnesses, you see the jurors looking over at one another, but it's not necessarily who's sitting next to you is the one you speak to. It's clear that there are certain jurors who are friendly with other ones. For example, there's a woman in the front row, sits in the 5th seat in the front row, who often seems to talk to a woman who sits in the 3rd seat in the back row. And they often seem to laugh with one another during the breaks and sometimes make jokes. And these jurors at times are almost cracking up during some of the breaks as they just joke with one another and talk. But they do look at O.J. Simpson sometimes, particularly because that is the time when they can see O.J. Simpson the most clearly. None of the attorneys are really blocking their view, although I should point out that during the sidebars, the defense always ensures that there is at least one attorney sitting with O.J. Simpson.
Bob? Dan, I'd be interested. Today, everyone's talking about the impact of the prosecution's rebuttal witness, the FBI agent who really shot down Dr. Lee's very important testimony. So everyone in the media, all the commentators are talking about it. I'd be interested in your sense today. Was this one of those days? Was this testimony where suddenly people were writing down notes? Did people seem to be reacting on that jury? Or was this just another day toward the end of a trial where this jury is just bored to tears?
You may be able to help me understand this one. I generally gauge how attentive the jurors are by how many notes they take. Whether or not that's a good idea or not, you can tell me. But today it seemed that they were attentive. They really seemed to be paying attention, yet very few of them seemed to be taking notes. They really didn't seem to be writing down what he was saying, but it wasn't as if we were hearing some of the very scientific testimony where sometimes it appears that the jurors are completely glazed over in their eyes and they don't seem to understand what was going on. That is not what was happening.
Well, Dan, you raise a question which I'll put to Robert Hirschhorn. What do you make of these strands of observations that we've got here? Some of the jurors bonding, some of them looking over at Simpson. Does this come as a surprise to you? What can you make of it? What did you tell your client at this week's
Great. Great question, Terry. I think a couple of things. Number one, the deliberation process has already begun. And what I mean by that is, as a result of sequestration, the jurors have bonded into little groups, kind of like when we were in high school and we'd have the little cliques. Well, what we heard from Dan is some of that clicking process has already begun as a result of sequestration, and they'll take that into the deliberation process. By looking at O.J. Simpson, you learn who has got the courage to look at this person, this defendant, the person who's accused of these horrible crimes. When the jurors are talking among each other, cracking up, I mean, this is a murder trial. And yet at these breaks, they're cracking up. That gives you some insight as to, but the most telling, I think, and I think Dan's right on the money again, jurors at this point are not taking notes, Terry. I think that is a red flag that goes up and said, let's go. It's a red flag that they've made up their mind, they're ready to go deliberate.
Dan, let's go back to you on that.
Terry, while almost all of the jurors appear to look over at O.J. Simpson on a somewhat regular basis, not all of the jurors look at the victims' families. And I do watch their eyes closely. I sit right next to the jury box, and so if they turn to look at the victims' families, I really can see them doing that. And it seems that there are really only 4 jurors who on a regular basis look over at the Goldman family sitting in the front row. And I say 4, including the 2 alternates, because one of the people is one of the alternates. Again, I don't know what that means, but it is interesting to see that it is the same jurors on a somewhat regular basis who are occasionally looking over at the Goldman family.
And that raises a question I want to put to our trial lawyer, Bob Gottlieb. Closing arguments coming. When you're standing in front of a jury that you've been in front of for a long time and you get the sense that maybe there are these cliques or that maybe, people are beginning to divide up, do you try to shape your argument to specific jurors?
Do I try to shape the argument? Not necessarily, but whatever the argument is, if I think I have a compelling argument and I think there's a key juror who appears to have been a leader in a very long trial, I'll talk directly to that juror. I will, during my summation, go up and down that jury box, and if I think there's one juror who I want to make sure gets this point, I'll go right up to that juror and I'll talk directly to that juror. And then if there's somebody else who I want to address, I might go and make eye contact with that other juror. So you definitely are very aware. I don't stare at the jury during the trial, but during my summation, that's the time I then connect directly with each and every one of them.
Let me wrap it up here with one final question for Robert Hirschhorn. The Simpson case watched to an unprecedented degree. a lot of people beginning to question, I think, the wisdom of the jury system. People don't like what they see for whatever combination of reasons. What do you think we'll learn from this trial ultimately?
You know, to measure this trial, to measure the American judicial system by this trial would be unfair to all of us, Terry. And Court TV has done a remarkable job at informing the American public of how trials really work in our system. Some trials go very well, some trials don't. This is one of those that has really stretched the limits of the system. Here's the most important lesson we've got. Number one, I think the issues of reasonable doubt have been brought back into the front in the minds and hearts and souls of the American people. I think the presumption of innocence and all of the issues that go with that are back in the hearts and minds and souls of the American people. But the most important thing that I hope we all get from this is that when we get that notice in the mail to do the jury duty, one of the most important civic duties we as Americans, one of the most important privileges we have, I hope all of us don't say, oh, I don't want to get involved. I hope what this case does to all the American people is say, yes, I do want to go down and do my civic duty. I do want to be part of the process. I'm not going to sit back and criticize. I want to be part of the decision-making process. And I think the case has done it.
Well, on that note, we'll close it out. Robert Hirschhorn, thanks very much for joining us tonight on this subject.
Thanks, Terry. Thanks for having me.
And Dan Abrams, thanks for staying late on a Friday night with your observations. We'll see you next week.
Thanks.
Well, we're going to take a break, and when we come back, we'll go back to testimony, the testimony the jurors heard, print testimony or lack thereof from FBI Special Agent William Boziak.
Would it be misleading to come in here and try to rebut testimony and statements that weren't even given?
It's just the morning and you don't need to caffeinate it for two.
Wake up to Folgers Coffee Singles, made with ground roast decaffeinated coffee for one freshly brewed cup.
The best part of waking up
Is Singles in your cup.
Clogged drain? Professional strength liquid plumber drain opener doesn't dilute in standing water. So, more of the good stuff hits the hair clog. So, it's the strongest you can buy. So, I hate it.
Sorry, plumbers.
Anacin, more relief than the regular strength of Bayer or Tylenol. Anacin, when you really got a headache.
Forget about these antiperspirants forever. Because now there's one that keeps you drier. New Sure Ultra Dry. It's a whole new kind of antiperspirant. A soft solid. Just 2 clicks, and it goes on dry to keep you ultra dry. Look, ordinary solids can flake off, but New Sure Ultra Dry vanishes in to form an invisible layer of protection that keeps you drier than ever before. See for yourself. New Sure Ultra Dry. Goes on dry, keeps you ultra dry.
Are we all set? Yeah, ready.
All set.
Can you adjust that light for me?
Yes.
Screen that, please. Thanks. Can we get 2 PA stats? Left side, left side. Can I have a clip? Right side. Scissors. High right. High right.
Keep going. Keep going.
You got good pressure. Good pressure.
Hold him steady. Looking good.
Now back to the testimony today in the O.J. Simpson case. FBI Special Agent William Boziak took the stand for the prosecution and really laid into the findings of the defense expert Henry Lee concerning what Henry Lee contended were imprints found at the crime scene on Ron Goldman's clothes and in particular on the tiles at Nicole Brown Simpson's condominium. Boziak said they weren't imprints at all, or if they were in the tile when the concrete was poured. On cross-examination, Barry Scheck tried to protect Henry Lee a little bit by saying, through his questioning here, that Henry Lee never said what the witness and prosecutor Marsha Clark said he said.
Mr. Boziak, you've testified here that you were familiar with the majority of Dr. Lee's testimony. You said that today.
Probably about 90 to 95%.
Well, yesterday, didn't you tell us that you were didn't read it?
I haven't read his testimony. I videotaped or saw on TV approximately 90 to 95% of his testimony.
Didn't you tell us yesterday that you had seen portions of it on news clips?
I said that I had seen the majority of it on tapes of his testimony, continuous tapes, and I had seen some other recordings and news clips of parts that I didn't see.
Well,
on the original tapes.
Yesterday, you said yesterday you saw the majority of it?
Yes.
Now, you feel confident that you fully reviewed and studied his testimony in a way that gives you confidence that you can criticize what he said?
I'm not here to criticize what Dr. Lee said, but to clarify it so it's not misleading, that the term imprints was not a shoe print, in my opinion.
Well, first of all, Dr. Lee used the term imprint, correct?
That's correct.
And with respect to testifying as to a shoe print, the only full shoe print and pattern that he testified to was the one that had been labeled 1337A, correct?
Could I see that?
Yeah.
Yes.
Okay. That was his testimony, correct?
Yes, I believe he was questioned several times throughout his testimony to clarify whether what he referred to as imprints he could positively say were shoe prints, and he qualified his opinion that he could not positively say they were shoe prints, with the exception of that one that you're just referring to.
Well, he did that on direct.
Yes.
He was very clear about it, wasn't he?
I didn't perceive it as clear all of the time.
Well, do you recall the distinction that Dr. Lee made? Well, would it be misleading to come in here and try to rebut testimony and statements that weren't even given?
Argumentative, sustained.
Well, you talked about misleading the jury and your concerns about it.
I was confused myself in watching his testimony whether he was referring to shoe prints when he used the term imprint on many occasions. If I were confused, I'm sure that other people could be misled in his explanation of certain things.
Well,
Barry Scheck has demonstrated in the course of this case that he is, for the most part, a cross-examiner who can control a witness on the witness stand, but William Boziak on the stand being able really to handle this examination and make the point he wants. When we come back, we'll hear Barry Scheck continue his effort to rehabilitate the witness who's really under attack here, Henry Lee.
Anacin, more relief than the regular strength of Bayer or Tylenol. Anacin, when you really got a headache.
The city never sleeps. When we go home, the professional cleaners go to work with their pro-strength cleaning formulas, like Pro 409 Spray Cleaner. Super concentrated for the toughest cleaning jobs. To clean like a pro, get Pro 409.
Who taught you how to shave your legs? Your mother?
You start with a bar of soap, work up a good lather.
Sometimes I use your father's shaving foam.
Skintimate Shave Gel has a rich blend of 8 moisturizers, including vitamin E.
True, soap may dry your skin.
Skintimate protects against the nicks and dryness a soap and water shave can cause.
These little bandages are a perfect fit.
Skintimate Shave Gel. There's no softer way to shave.
Did you know you could be paying hundreds of dollars too much each year for your life insurance? Well, it won't cost you a cent to find out. That's because a company called Select Quote Insurance Services continually compares the cost of term life policies from the nation's top-rated insurance companies. For example, if you're a man 35 years old and a non-smoker, you can get $150,000 coverage for just $165. If you're 45, you can get $250,000 coverage for just $260. Call now, and Select Quote will mail to you absolutely free a personalized price comparison of the 5 lowest quotes to study in the privacy of your own home. Remember, these are unbiased quotes from companies aggressively bidding for your business. There's no obligation whatsoever for the price comparison, and it's free. Get the most life insurance for the least amount of money, period. Call Select Quote now and see how much you can really save.
Call 1-800-824-4000.
Defense lawyer Barry Scheck continued his cross-examination of FBI Special Agent William Boziak as Barry Scheck continued to try to salvage some of the important findings of Henry Lee, the defense forensic science expert, from what has been a sustained attack in the prosecution rebuttal case. On this line of cross-examination, Barry Scheck discusses the timing of the deposit of some of the blood on the prints. You may recall that a print left on the envelope at the scene had some blood run over it, and that, according to Henry Lee and the defense, shows that it was left at the time of the killing. And Barry Scheck, here in his questioning of William Boziak, says that nothing that the state can say can counter that.
These are, do you recognize these as three different pictures of the envelope?
May I step down?
Yes, please.
Yes, I do.
And did you see Dr. Lee testify about this?
Yes, I did.
With reference to this board?
Yes.
Now, yesterday you gave testimony about a flash bounce, correct?
Yes.
Now, in terms of identifying the differences between the picture in the middle, which you recognize to be the first picture taken of the envelope, do you not?
I don't know what order they were taken in.
Well, you remember that there was a picture taken with Mark Furman pointing at the Bundy glove, and then close-ups were made of the envelope as it was at that position at that time.
I don't know what sequence we were in. I know which photographs you're talking about. I just don't know what sequence they were in.
Well, do you recall the testimony that the sequence was the middle picture was the envelope from the Furman photograph, and the one to the left was a subsequent photograph taken at the crime scene with the evidence marker, as you can see in the top here.
I see they're different photographs. Again, I don't remember the exact sequence of it.
Now, in regard to this board, do you think that a flash bounce moved the hair, fiber, and trace that you see in the middle picture that we now see in the left-hand picture?
Just rephrase the question.
All right, you see that there's hair and fiber, the trace evidence in the middle picture.
And objections to be on the scope here.
Oh,
You see that?
Yes.
Do you see it in the left-hand picture?
You point specifically to what you're referring to?
Yes. Hair, fiber, and trace at the top of the envelope here. Do you see it in this picture here?
You're referring to all of this material which appears black
Yes.
on the center envelope. And over here, no,
Yes.
I do not see it.
All right. And could flash bounce be responsible for the differences in these two photographs with respect to the hair and trace?
I would not.
Objection to characterization of the trace matter.
I would not attribute flash bounce to eliminating all of this. There may be differences in exposures and lighting that would account for minor things, but not for a large quantity of material.
So flash bounce couldn't have moved that material off the envelope, in your opinion?
That's correct.
And you are aware of testimony in this case that these two pictures represent the envelope being moved from one place to the other?
I don't recall that particular testimony, no.
You don't recall Dr. Lee putting up boards and showing the movement of the envelope from one place to the other?
Objection beyond the scope irrelevant.
I was listening to his testimony as it pertained to footwear impressions.
So your answer to that is no?
I don't recall that exact statement.
All right. But you would agree that flash bounce can't move an envelope from one place to another?
Of course not.
Thank you.
Well, I misspoke. That line of cross-examination by Barry Scheck addressed to the defense contention that evidence was moved in this case. One of Henry Lee's findings was that there was clearly some kind of deposit from leaves or dirt on the envelope in one picture, and in another picture that deposit was gone, indicating that somebody had moved the envelope, moved the evidence. When we come back, we'll hear Barry Scheck questioned William Boziak on the timing of the deposit of blood in this case.
For the latest programming information seen on Court TV, call 1-800-COURT-56.
I cut my vitamin bill in half, thanks to Puritan's Pride.
I saved over 50% on my vitamin purchase. Shopping with Puritan's Pride is like putting money back in your pocket.
Hundreds of thousands of people are buying their vitamins, minerals, food supplements, and more from the pages of Puritan's Pride. Why? Just look at our fantastic 2-for-1 prices. Imagine getting not one, but 2 bottles of C500 with rose hips, both for just $4.95. 2 for the price of 1. And look, buy 1 bottle of ginseng and get another free. 2 for $6.25.
I bought 1 bottle of lecithin and got another one free. Just $4.65 for 2 bottles.
Buying from Puritan's Pride means you're buying direct from one of America's leading vitamin manufacturers and one of the largest. We offer a tremendous variety of products. Hundreds of the finest vitamins, minerals, food supplements, and herbs, including the newest products nutritional science has to offer. Puritan's Pride offers you a full money-back guarantee on every purchase. So call now for your free 96-page Puritan's Pride catalog.
Puritan's Pride, the smart way to buy vitamins.
Welcome to a new way to communicate. A new source of news, information, and software available through your computer 24 hours a day. This is the official America Online Tour.
Let me show you how America Online really works. You just point and click.
You've got mail.
Hey, I've got mail.
You can send and receive email even across the internet.
I've done that. Really?
Scan the latest headline. Browse Time Magazine. Find out what's on TV with ABC Online. Look up facts in Compton's Encyclopedia. You can even explore the Smithsonian right on your computer.
My son gets help with his homework.
Call now for your free trial. You'll get free software and 10 hours of free online time your first month. America Online. It's knowledge. It's power.
And?
Okay, it's fun.
Call now for no obligation free trial of America Online. You'll get free startup software and 10 hours of free online time your first month. Call now, 1-800-535-6700. What have you learned from the O.J. Simpson trial so far? That real justice is messy, unpredictable, riveting, important. That's the truth behind our entire legal system. That's why Court TV takes you far beyond the camera in the courtroom. Every weeknight after Primetime Justice walks the whole spectrum of America's legal system, from investigation to confrontation to the aftermath of the verdict. Court TV weeknights after Primetime Justice. Real drama, real people, different television.
Plug into Court TV's Law Center with your home computer and America Online. Discuss the hot legal issues and get 24-hour access to Court TV's daily coverage. Call now and sign on today.
One of the things that Barry Scheck is trying to accomplish in this cross-examination of FBI agent William Boziak is to show the jurors that much of what Henry Lee talked about is not impacted by this rebuttal testimony. And in this line of cross-examination, what Barry Scheck tries to show the jurors is that the blood running over one of the prints in this scene, which the state says is left by Ron Goldman's own clothes, which the defense contends is left by the foot of another killer, that however it was left before these murders were fully accomplished.
All I'm asking you is that you said yesterday you were answering in response to hypotheticals, right?
I gave a hypothetical of how that impression could occur without surrounding features in an island configuration.
Right.
At that size.
Right.
Yes.
And what you were saying is, if it occurred earlier in the struggle where there were just a few blood drops that might have gotten on the sole of a shoe, you would get an imprint without non-printing area around it and without a border, right?
I never mentioned anything about blood drops on a shoe in this case, but in the hypothetical context, it said it could be a drop of blood on any object, hypothetically including a shoe, and that is how you could get the isolated island impression.
Right, and that was on direct. You offered that, right?
Not as a shoe in this case, but as a hypothetical event, yes.
Yes. And you said that would be the only possible way it could happen, right?
That was one way in which it could happen.
Well, but you were unaware of this board and testimony that Dr. Lee gave supporting his contention that that imprint occurred earlier in the struggle before subsequent deposits of blood were on the envelope.
The sequence of the events with regard to the blood deposition on the envelope has no influence on my interpretation of those parallel lines. Whether they came before or after would have no bearing on my overall interpretation and opinion that that is not a shoe print.
It's not a shoe print. That's the bottom line from FBI agent William Boziak. What Barry Scheck was trying to do there is to say that this very small area of parallel lines, which is made in blood, could have been made by a shoe stepping on one drop of blood and then stepping on the envelope. William Boziak wasn't going for it. Bob Gottlieb, thank you. I had Robert Hirschhorn here, so I'm a little confused. We've seen Barry Scheck a number of times in this case. Do you think he's struggling here a little bit, like me?
Is he struggling? The answer is yes. Barry Scheck is a great lawyer, and he's done a great job in this case. On rebuttal, especially if you don't have the same time to prepare as they did with the steady stream of witnesses on direct examination by the prosecution, sometimes you're caught surprised. So you haven't formulated your cross-examination to keep it focused. But you can almost sense that Mr. Scheck is sort of groping to finally get online, and I think he was toward the end. You would much prefer, right from the beginning, to grab the jury, keep it focused on the issue that you're talking about, make it clear to the jury that while you may now say that in the cement that's not a shoe print, you don't disagree with Dr. Lee when he said this. You don't disagree with Dr. Lee when he said this. You don't disagree with Dr. Lee when he said this, because the defense right now is in danger of jurors saying, you know what? If Lee is wrong about that second imprint in the cement, then he's wrong about the envelope and he's wrong about everything else. So you really want to focus on, there may be 100 other bits of his testimony which this witness is not contradicting even in the smallest way.
What you've got with this witness, he is not only a shoe print expert, but a veteran witness, an expert witness in testifying, and he not only isn't budging for Barry Scheck, but he seems to be taking control of the examination. Long answers. He's able to spin out his opinion once again. Is that avoidable for a defense attorney with a witness this strong?
Sure. You have to form your question in a way where the witness really must answer either yes or no. You're not disagreeing with Dr. Lee when he said this, are you? Yes or no? You're not disagreeing when he said this. That's the way you try to control a witness. But a lot of times you can formulate your questions only if you have enough time to think it through. If they were caught off guard at all by this witness's direct testimony when called by the prosecution, it's understandable that right out of the box you may not have formulated your questions in such a precise way.
You know, we heard Barry Scheck bring up the name of Mark Furman once again in here in conjunction with the evidence-moving photographs that he was showing. And is this obviously it's going to be a strategy of the defense here to put Mark Furman everywhere they can in this.
Well, I think when they say good morning to the judge, they may say good morning, Mark Furman. Oh, excuse me, Judge Ito. I wouldn't be surprised if from this point until the end of the trial we hear Mark Furman's name and then corrected by the defense attorneys time and time again. They will not end this trial without mentioning Mark Furman and perhaps trying in a desperate way to get across to this jury that Furman still hasn't retaken the witness stand.
How could you do that if you're a defense lawyer? In closing argument, you want to get the message across to the jurors. What happened, that extraordinary situation? How can you do it?
Well, I think the only way you're going to be able to do it is based on the evidence. You heard Detective Furman say this. You heard that there are certain questions about the planting of the evidence, questions which could have been answered if he had gotten on the stand. We didn't hear Detective Furman ever again. Detective Furman only testified one time. You can do it in many ways. The prosecution may object, but with a defense attorney, all you have to do is mention it. And even if the judge sustains the prosecution's objection, what is the judge going to do? Declare a mistrial? That might happen with a prosecution. If the prosecutor improperly mentions Mark Furman or some other witness, they stand in danger of a mistrial, and then the defendant goes free. With a defense attorney, you can mention it, and the judge is just going to say, you do it again, I'll hold you in contempt of court.
So a little more leeway and an artful way, Bob, of getting Mark Furman's situation perhaps before the jury based on the evidence. When we come back, we're going to break away from the Simpson case and turn to the trial we've been covering in Fort Lauderdale, Florida, of Peter Lopez.